So now it has started and it's being recorded, okay? We have got 9 attendees. Hang on a second. Yeah, Justice Shah, please go ahead.
Good day to all of you. Thank you to Dr. Reayat for inviting me to be a part of this conversation. This panel discussion provides a comparative analysis of judicial independence in established democracies such as the UK, USA, as well as authoritarian states and weak democracies such as Pakistan, Colombia, Indonesia, Egypt, and others. As a former judge myself of what we like to call the world's largest democracy, I am always curious to understand how judicial institutions across the world are perceived by practitioners and academicians. How do judiciaries work in systems built on a separation of powers? Theoretically, one would expect true impartiality, but in practice, different conditions appear to affect the functioning of judges in different jurisdictions. These distinctions are especially stark when one looks closely at decisions involving matters involving the state and political ideology. Are judges influenced by or partial to the state, even say in established democracies? How about in the United States, where judicial appointments are by design political? How do such appointments affect the quality and outcome of decisions? In my opinion, there have been some terribly disappointing decisions from highly politicized US courts, recent times, particularly like Texas abortion decision being the latest in a long line of such. On the other hand, how do you explain judges, at least sometimes, acting fiercely independently, even in authoritarian states or weak democracies? Here I recall Pakistan Supreme Court suspending the decision to grant a term extension to the powerful Army Chief General going against the Prime Minister. Can an independent judiciary exist without having an established democracy? If yes, how does one account for situations where judges with no power of purse and firearm behave independently of authoritarian leaders who possess both? Few studies have compared judicial independence in established democracies with in authoritarian states to answer the above questions. Therefore, this panel discussion will be the first of its kind to bring together scholars in different contexts whose work focuses on judicial independence to promote a comparative discussion of judicial in established democracies as well as authoritarian states. Today's discussion will last for 1 hour and 30 minutes approximately. The last 30 minutes will be for our audience to raise questions and to participate. Towards the end of the presentations, I will add a few observations about the position in India and will bring my perspective as a former judge on what I perceive to be the interplay of law and politics here. With this brief introduction, I now invite our first speaker, Professor Roger Masterman, who is Professor of Constitutional Law at Durham Law School. His recent projects include an essay on Brexit and the United Kingdom's devolutionary constitution, and a study of the influence of Judicial Committee of Privy Council decisions on constitutional decision-making in the UK Supreme Court. Professor Roger Masterman.
Okay, thank you very much, Chief Justice Shah, and thank you, Nauman, for the invitation. Okay, so my focus initially is at least on the United Kingdom and the issue of, or the issues surrounding judicial independence and its relationship with the political climate. as many of you will know, debates surrounding judicial independence in the UK have tended to focus either on the individual decision-making capacities of judges or the arrangements surrounding and underpinning the courts as institutions within the constitutional architecture. The first of those, the idea of individual judicial independence, is surely the most firmly established and is underpinned by, among other things, commitments to security of tenure for senior judges, by principles that governments will not seek to comment on or influence proceedings in progress, and by a well-established jurisprudence relating to bias and to perceptions of bias. See on that, at least, for instance, the famous Dimes case and the no less famous Pinochet decision. The independence of individual judicial decision makers is a significant long-standing component of our constitutional framework, and in its modern form, at least, is traceable back at least as far as the Act of Settlement in 1701. The institutional independence of courts is perhaps a more recent addition to the UK's constitutional framework. The severing of links between courts and the more overtly political branches of the government in the UK. By this, I mean the stripping of judicial functions from the office of Lord Chancellor, a cabinet minister, and the reformation of the Supreme Court as a structurally independent body rather than as a committee of the upper house of Parliament marks the high watermark of this particular element of the UK's judicial independence matrix. But protections recognising the institutional distinctness of the judges from the other arms of government can be found elsewhere in our constitutional arrangements, in the House of Commons Disqualification Act, for instance. Institutional independence is perhaps most obvious in relation to the absence of physical or personnel linkages between the judges and the other branches. But, as Jack Beatson has recently suggested, it also extends to the idea of public confidence in and public support for the judiciary as a whole. But what we might call the jurisdictional elements of judicial independence are perhaps less obviously articulated in the UK's constitutional order. This is partly, of course, due to the infamously malleable relationship between the UK Constitution and ideas relating to separation of powers. And in turn, it's also partly attributable to the constitutional hierarchy, which results from the sovereignty doctrine, the doctrine which, of course, places statute rather than judicial judgment or indeed executive will above all other constitutional sources. But persistent doubts around our responses to two questions in relation to jurisdictional elements of judicial independence provide cause for contemporary concern. The first of these questions is, what are judicial functions in the UK Constitution? Judicial functions, as distinct from those exercised by the executive or legislative branches, arguably have no precise definition in the UK constitutional order. As with much of the UK's constitution, we must piece together fragments of case law and legislation so that we can discern a coherent overall picture. If we look a little bit deeper, there is, of course, a partial and indeed highly specific, in the context of executive involvement in sentencing decisions, jurisprudence on certain functions which are deemed to be judicial in nature. There's also a body of jurisprudence found, for instance, in Lord Justice Law's judgment in the Cart case, relating to the constitutional necessity that law be interpreted by an independent and impartial arbiter. But of course, all of this talk of judicial functions or the constitutional necessity of interpretive functions needs to be understood in the context of a system in which sovereignty dictates that the law to be interpreted may be changed by Parliament. The second question is, what are justiciable questions? These are similarly ill-defined and subject, currently at least, to a reasonably heated debate centred on the appropriateness of judicial engagement with, for want of a better phrase, political questions. Questions which sit at the intersections of law and politics have been steadily entering the mainstream in the UK, partially as a product of legislation such as the Human Rights Act and the Devolution Acts, partially as a product of the longer-term expansion of the judicial review system. As to the latter, the gradual erosion of those areas of prerogative which might not be susceptible to judicial review provides a case in point with the Miller-Cherry decision of the UK Supreme Court, in which the prorogation by prerogative of Parliament attempted by Boris Johnson in September 19 was found to be of no legal effect. The Miller-Cherry case also perhaps provides the high point to date of controversy regarding the court's supervision of judicial review. Though we don't need to look far, supervision by way of judicial review, though we don't need to look far to find other instances of similar controversies. The first Miller decision, the Nicholson decision on assisted suicide, decisions on prisoner voting, and so on. Controversy over the extent of judicial supervision of political decision-making is, of course, in one sense, a pervasive issue across constitutional systems. I'm not seeking to suggest that it's not an appropriate topic for debate or for concern. But the debate around judicial power in the UK serves to highlight the weakness of the judge's constitutional position. Perhaps it's especially so in the United Kingdom's political constitution, because such controversy serves to remind that our sense of the jurisdictional autonomy of courts, that is, the space in which they might legitimately provide independent judgment as to the requirements of the law, is both subject to legislative direction and redirection, but also to the prevailing political climate. Of course, the effectiveness of all dimensions of judicial independence is contingent on a degree of political or constitutional stability. And while we've not in the UK seen concrete attacks on judicial independence or institutions, as are evident from the recent experiences in, for instance, Poland, we have seen a number of episodes which hold the potential to exercise a destabilizing effect on judicial independence in its various guises. The most obvious of these threats are to what is to be seen as the legitimate sphere within which judges take decisions. The best example in this regard is the climate of constant potential reform in which the UK's Human Rights Act operates. The Human Rights Act, from virtually the point it was fully operational, has operated in a climate in which successive prime ministers have threatened to curb the extent of the powers allocated to the courts, or either review whether the balance it strikes is appropriate for the protection of rights and perhaps for the government's interests. While a constant climate of potential reform might only weakly destabilize judicial independence, we've also seen more direct threats, i.e. to abolish the Supreme Court and revert to the status quo ante, a threat that's now potentially translated into the Conservative government's plan to review the Constitutional Reform Act, the act that established the Supreme Court. As a result, we see a concern relating to the extent of judicial power potentially translating into a reform with the potential to directly impact on the institutional position of the court itself. A concern perhaps exacerbated by the fact that the current Lord Chancellor has recently suggested that his office be reinstated to hold a central role, or a more central role, in executive judicial relations. Weaker attacks are perhaps no less damaging, again, with the potential to have knock-on effects. The infamous Enemies of the People episode, in which judges of the divisional court were portrayed as having defied the will of the people in order to advance their own pro-European sympathies, perhaps remains the nadir of press coverage holding the potential to damage public perception of the judges. But again, we don't need to look too far to find other examples of the normalization of this kind of attack on judicial decision-making. Tony Blair, David Cameron, Theresa May have all had episodes in which they have publicly and seriously criticised individual judicial decision-making. Beyond this, the current Prime Minister and Home Secretary routinely invoke the trope of the lefty lawyer, further suggesting that the legal profession pursues party political objectives, and the judges, of course, are guilty by association. As these criticisms of judicial decision-making become normalised, the idea of judicial comity, or the respect between institutions that provides a foundation for judicial independence, is gradually undermined. So while the core protections for judicial independence in the UK are reasonably robust, the institutional and jurisdictional elements of the idea operate in a potentially destabilising political environment. So in conclusion, we should be careful not to assume that the relative stability of the UK's constitutional order provides judicial independence with complete immunity from the threats posed by populist and anti-constitutionalist tendencies of governments and their sympathisers. So I'll stop there.
Thank you, Professor Masugan, for that insightful presentation. May I now invite our second speaker, Dr. Moohyung Cho, who is an assistant professor in the Department of Political Science and International Relations at Ewha Women's University, South Korea. He received his PhD in political science at Duke University in 2020 with a specialization in comparative politics and political institutions. Dr. Cho.
Okay, great. Let's get started. So first of all, many thanks for inviting me to this great panel discussion. And actually, it's my first time to join an academic event in the UK. So I'm very happy to meet all the audiences from the UK and beyond. And I am a political scientist, and I study judicial independence in authoritarian regimes in empirical and comparative cross-national perspectives. So I hope that my presentation can be a good complement to the presentation of other speakers who take relatively more legal and qualitative approaches of judicial independence in established and emerging democracies. So I have been studying for many years to identify political and economic conditions for the development of reasonably independent courts in the authoritarian world. When developing my academic interest, I have to fight against the conventional understanding that the judicial independence does not exist in autocracies. When we think about the typical images of authoritarian courts, they represent the repressive state apparatus that sideline political opponents, and judges often blindly make decisions in favor of the regimes and often regarded as the regime's puppet. So judicial independence has been widely understood as a principle of liberal democracy, and this understanding creates a kind of some skepticism that the judicial independence is incompatible with authoritarian politics. But for the past 10 to 15 years, there has been a growing literature in comparative judicial politics that challenges this conventional view and examines the presence and development of judicial independence and the rule of law in many authoritarian countries. So after reading these pieces of the literature and looking at the empirical data sets and observing real-world cases in the authoritarian world, I'd like to share my three major observations of judicial independence in autocracies. So the first observation is that the level of judicial independence has been actually growing in the authoritarian world. So in this figure, the blue bar means the number of authoritarian countries in each year. And then the black dot here indicates the mean value of the judicial independence in the authoritarian world in each year based on the famous Linzer and Staten's measure about the de facto judicial independence. So as you can see, starting the mid-1970s, which is called the third wave of democratization, the level of judicial independence in the authoritarian world has made a steady increase. And then even after the many autocracies turned into democracy after the end of the Cold War, the level of judicial independence has been quite steady and reasonably high in many authoritarian countries. The second observation is that the judicial independence in authoritarian regimes is often compartmentalized, and its economic aspect is being predominant. So although autocrats may be reluctant to establish politically independent courts that may challenge their role, the autocrats' concern about economic development motivate the autocrats to build the independent courts, at least in the economic sense. So to capture this idea, here I created two figures to understand such a phenomenon. And then as you can see, here I picked the two components of judicial independence that is drawn from the data set about the World Justice Project's the Rule of Law Index. And the x-axis is the government powers limited by the judiciary, which captures the political aspect of judicial independence. And the y-axis here is no expropriation of property rights, which is more related to the economic side of judicial independence. And each dot indicates the authoritarian countries. And you can see that most of the dots are located above the red 45-degree line, which suggests that in many authoritarian countries, economic side of judicial independence has been better scored compared to its political aspect. And then the box plot on the right also gives us further evidence by showing that the differences between these two types of judicial independence is greater in authoritarian countries rather than in the democracies. So here we can find that the judicial independence has been selectively developed in many authoritarian countries, and the economic aspect of judicial independence has been quite dominant in the authoritarian world. And then the third observation, and maybe the most important observation, is that the real issue of judicial independence in authoritarian countries is not about its establishment, but about its maintenance. So this is basically related to the fundamental feature of authoritarian politics, because autocrats have overwhelming arbitrary power, they can do whatever they want, and such opportunism is hardly constrained. So as the Milan-Zvolik rightfully argued, the promises made at one point by the dictator may be broken later when they become inconvenient. So the autocrats have the old-time incentives not to promote judicial independence if they think that these courts are no longer necessary. So as the Mahathir, the longtime political leader in Malaysia, remarked in his interview, he said that if we find out that a court always throws us out on its own interpretation, if it interprets contrary to why we made a law, then we will have to find a way of producing a law that will have to be interpreted according to our wish. I think that the issue of the maintenance is an important, but the underexplored area to the study of judicial independence in autocracies. Many existing studies have a nice job to provide compelling reasons why autocrats want to establish independent courts for economic or political reasons. But they pay little attention to develop mechanisms through which once established independent courts can be credibly maintained in authoritarian regimes. There might be two possible reasons why judicial independence is hard to maintain in autocracies. The first reason is related to the inherent nature of independent courts themselves. So by nature, building independent courts is a political leader's commitment that they are committed to tying their hands, restraining their power, and respecting judicial decisions, even if the courts rule against them. But the question I may ask here is, if autocrats are rational, why do they voluntarily respect independent courts that may be adverse to themselves and their political future? So here, it's really important to think about which conditions change the autocrat's calculation of costs and benefits of independent courts, and then make the maintenance of independent courts as their rational and equilibrium behavior. The second reason is that many autocracies lack binding institutional devices to punish autocrats reneging on their initial commitment to judicial independence. In democracies, leaders are disincentivized to renege because such attempts are often blocked by institutional veto points or sanctioned as unaccountable by voters in elections. But those institutional mechanisms to induce political leaders' credible commitments are absent or weak in many autocracies. So autocrats create formal rules, but these rules constrain the road, not the ruler. So the difficulty in maintaining judicial independence in autocracies comes from the fact that there are no institutional solutions to the problem of autocrats' potential reneging. So the key question I have been tackling throughout my research is, given the lack of institutional devices to constrain autocrats, how can they maintain judicial independence without being tempted to undermine it? Of course, this is not an easy question, but in my previous dissertation and current book project, I have been working on building the theory on the maintenance of judicial independence in autocracies and testing them through the various methods. So briefly speaking here, I'm focusing mainly on the economic dimension of judicial independence, that courts provide a legal protection of individual property rights against state expropriation. And here I'm also highlighting the effect of the foreign direct investment on judicial independence in autocracies. So my theoretical claim is that if the autocratic countries' economic reliance on FDI creates some strong and ongoing incentives for autocrats to maintain independent courts as a property rights assurance to foreign investors. In general, foreign investors have strong preferences for independent courts in the host country as an institutional safeguard of their investment assets. And if the autocratic countries rely heavily on FDI, the foreign investors have a greater bargaining power vis-a-vis the autocratic government, and then they take advantage of such their increased leverage to demand better institutional protection of their investment assets. Foreign investors also have a mechanism to sanction autocrats' potential reneging on judicial independence, because in such a case, the foreign investors may threaten to withdraw their investment or even leave for the better business environment. So in such a situation, the foreign investment can be an effective constraints from without that may lead to the autocrat's credible maintenance of judicial independence. So this is the project now that I'm now working on, and then I hope to, yes, I have so many stories to tell you about this, but I will stop here, and then I look forward to continuing the discussion about this during the Q&A session. So that's all I have. Thank you very much.
Thank you, Dr. Cho. That was a fascinating presentation with all your slides, and very instructive, at least for me. I've been hearing about this new dimensions about the judiciaries in the authoritative states. Now I will invite our third speaker, Dr. Patrick O'Brien, who is a public lawyer with research interest in judicial studies, law and democracy, and constitutional theory. He completed his DPhil on judicial review and democracy at St. John's College, Oxford. He's an honorary research associate at the Constitution Unit, UCL. Professor O'Brien is the co-author of The Politics of Judicial Independence in the UK Changing Constitution, and the co-editor of Leading Works in Public Law. Professor O'Brien.
Thank you, Chief Justice, and thank you, Nauman, for inviting me to speak today. Some of what I'm going to talk about echoes what Roger really has already said, so I'm going to try and not to overlap too much, but I hope that this is complementary rather than cross-cutting. I want to talk really about the links between judicial independence and political culture as exemplified in the changes that have occurred in the UK Constitution in the last 20 years or so in particular. And as a starting point, I want to set my story up comparatively, because building on empirical evidence that's been done in the political science side of judicial independence, there's very clear conclusions that cultural and political support for judicial independence is more important than formal legal guarantees. And there's loads and loads of stuff that I've listed a few on the slide there. We could talk about Feld and Voigt, who did a study of apex courts, supreme courts in the world, and what their conclusion was that if you look at the countries that have the best formal legal independence structures, and if you look at those who have the best de facto independence, so actual practical independence, there's no overlap there. All the countries with strong formal independence are not in the top 10 for the best actual practical real world independence. A much more recent study by David Kosar looked at judicial independence in emerging democracies in Eastern Europe after the transition from the Cold War. And following that process, very robust judicial self-government processes were put in place, legal structures to ensure that judges were completely ring-fenced from the other parts of government. And the consequence of that, Kosar found, was often inimical to judicial independence, because without the supporting culture that had built up over decades, that judges were supposed to be left to their own devices, that they were supposed to be significant, as Roger clarified earlier on, distinction between individual independence as opposed to institutional independence. We had, for example, senior judges politicking, promoting their friends, sending their political enemies within the judiciary off to whatever was the equivalent of the vehicle licensing office in Swansea for the civil service, or disciplinary processes concocted and so on. So without that supporting culture, the legal process didn't mean, the legal institutional protections didn't mean very much. Other work by Clark in 2011, work that I was involved in, the book on political independence, on judicial independence in the UK's constitution, suggests very much that, perhaps counterintuitively, judicial independence has to exist, requires political buy-in, and in fact that it's a political achievement. It's a structure that we achieve primarily through self-denying ordinances, conventions that are adhered to, respected, understood, and valued by the political branches of government. It's not something that judges and lawyers can insist on. Now, that's my comparative starting point. Let's look a little bit, and I won't bore you with this because this is fairly common knowledge, but on the historical situation in the UK. And judicial independence in the UK is long-standing. The main historical statutory point of this was the Act of Settlement 1701, which put in law for the first time the requirement that judges would hold office during good behaviour, and that they could only be removed by addresses to both houses of Parliament. So effectively motions and a mini trial procedure that would happen in Parliament. This, just out of interest, has only happened once in 1830 to a judge called Jonah Barrington, who had embezzled court funds. But actually the Act of Settlement is, that's your nuclear option. That's, you're going to fire the judge. It also doesn't apply to most judges, numerically speaking. It only applies to High Court judges, which is anyone in the High Court, Court of Appeal, and House of Lords, as was later Supreme Court. So Robert Stevens, a great legal history writer on the judiciary, talks about protection for the judges being significantly by tradition. It's not through law, it's through sort of codes of honor and through sort of practical social things. How do we protect High Court judges? Well, we give them knighthoods. Everyone knows a knight is someone who's important. Sir John Smith, he must be great. We'll have to leave him alone. We give them huge salaries, very high, certainly in the 19th century by comparison with other public officials at the time. And in terms of income, they would have been comparable with the kind of incomes that great landowners would have been receiving. And that various bits of that start to get attacked, start to get reduced in the 20th century. But by and large, the culture associated with that remains intact. But the big thing is the culture of political restraint. We have conventions against criticism of judges. We have particularly parliamentary rules like the sub judice rule, by which Parliament agrees that in most circumstances, existing court cases will not be discussed in Parliament. Now, that's not something that Parliament has to observe. It's actually a rule that can be relaxed if the speakers of either house wish to. It's a rule that Parliament obeys because it wants to, because it regards the independence of the judiciary as something that's important. There are also some of the doctrinal protections that Roger mentioned arising out of judicial review, natural justice, the rule against bias, a whole history of common law that arises there and in some senses predates the Act of Settlement of the things I've been talking about in the last few moments. So, but this is all kind of gradual, it's incremental, it's decentralized, and it's significantly cultural. And historically, this was compatible with lots of things that today we would not regard as compatible with judicial independence and with separation of powers, and certainly would be regarded as inimical to these things in other countries. So notably, the political involvement of judges in legislation and in politics, and particularly this focuses on the role of the Lord Chancellor. The Lord Chancellor in separation of powers terms was triple threat. He was the Speaker of the House of Lords. He was one of the most senior government ministers, cabinet ministers, and he was the most senior judge in the country, responsible for appointments, responsible for, to the extent that this was possible and was informal, responsible for judicial discipline. But this all existed, was compatible with judicial independence in the, I suppose, traditionally English cultural understanding of it, latterly UK understanding of that term. It was also consistent with appointment in by politicians, appointment of judges by politicians for political reasons, certainly up to perhaps the early 20th century, but done certainly independently without much oversight by the Lord Chancellor, by politicians, right up to the end of the 20th century. When does this start to change? Well, from the 1990s onwards, there are rumblings about this. The UK's accession to European Convention on Human Rights means that there are Article 6 ECHR issues that arise, a case called McGonnell, which dealt with an official from Guernsey who had a dual role in the legislature and in the courts, went against that kind of idea. The role of the Lord Chancellor, the role of the Law Lords came to be seen to be outdated. Some of the senior judges were upset with this continuing role, Lord Bingham notably, but there were also unrelated issues that contributed to this. The new Labour government that came into power in 1997 had a really significant political incentive and sort of manifesto commitment to constitutional reform and modernisation. They wanted to make the UK constitution look a bit more like comparative constitutions in other Western European countries. There's also personal politics that arises. The Lord Chancellor, who was in place under Tony Blair in 2003, effectively fell out with him, got into political difficulties, and his position became politically untenable. The government wanted to modernise the way the courts were run. So there were some issues that aren't really directly constitutional, but that also filter into this. So we get to the Constitutional Reform Act 2005. And what this does is it abolishes the Lord Chancellor as it had existed, in the sense that it removes the judicial and the speaker role. To my mind, completely abolished the role. There is an office still in place called the Lord Chancellor, but it is an exclusively political office. It is just a cabinet minister. The Law Lords were removed from Parliament, and all serving judges were forbidden from speaking in Parliament, from taking places in Parliament. A new Supreme Court was created. In practical terms, one of the most important things was that all the administrative functions that had vested in the Lord Chancellor were now transferred to senior judges across the UK. And there were new independent appointment and disciplinary systems. And what are the outcomes of this? Well, as Roger pointed out early on, we are in a system or a situation of serious constitutional uncertainty. I think a lot of the reforms that have been put in place have fairly shallow roots. And certainly there has been suggestions that some of the reforms in the Constitutional Reform Act would be reversed. The role of the Lord Chancellor might want to be restored. I think that probably goes beyond what I can talk about here because it's so uncertain. But just looking at what has been done and the effect of that, I think it's probably fair to say that the new Supreme Court works very well, that the administrative systems that are now controlled by judges work very well. Judges have proven themselves to be actually quite good administrators. They've set up good systems. Judicial training has been put in place. The judicial disciplinary system, I think, also works well. Whereas discipline in the past was informal, judges would be sort of put under informal pressure to resign if they did something wrong. There's now a possibility of written warnings, informal responses, being put on restricted duties. There's a wider range of disciplinary responses which allow for more fine-grained and therefore more effective discipline. The appointment system is a slightly different story. It's improving. It had quite a difficult birth. It has struggled to perform as well, certainly on judicial diversity, as the old political system that had been run by the Lord Chancellor. But let's look, those are sort of the successes or the half successes. Let's look at the threats. The administrative systems work well, but they're very poorly funded. The new government structures, the fact that the court system is not now this sort of special ring-fenced thing under the Lord Chancellor, but now a government department, the same as any other government department, means that even within the Ministry of Justice, courts compete with prisons for funding. Beyond the ministry, they compete with hospitals, with schools. And so these same funding pressures that apply everywhere in government apply equally to the judiciary and to the courts, with a consequence that the court estate is in a poor state in many areas. Sitting hours are reduced, and so on and so on. More direct threats to independence. Well, I think it's fair to say that political cultures around judicial independence have frayed, and Roger gave some examples of that in recent years. Some of this, I think we'd have to say, is a direct result of the reforms. Because Lord Chancellors are now exclusively political rather than legal, they rarely intervene in any kind of significant way to restrain criticism of judges or significant or politically difficult judicial decisions. Now, that's not completely true. It depends significantly on who the Lord Chancellor is. We have some conspicuous examples in the post-2005 era of Lord Chancellors who have stepped in, and equally, there are examples of the old Lord Chancellors in the pre-2005 era who didn't care at all. So it's not clear cut. But it is true to say that we see less and less from Lord Chancellors. We hear less and less from Lord Chancellors in this respect. And partly this is because they're no longer legal. It's also because they tend to be junior rather than senior ministers. They are young men and women on the way up rather than big political beasts at the end of their careers who wouldn't mind sending a letter to the Prime Minister because they don't care about the job anymore. They're not looking for anything. They're not trying to climb higher up the ladder. This isn't true of Lord Chancellors who are appointed now. They're junior people looking for something better. The Lord Chancellor is a stepping stone. It's also true to say that judges are no longer in Parliament to challenge political narratives that might be regarded as damaging judicial independence. And this is a nuanced picture. There are lots of retired judges in Parliament who do perform this function, lots of eminent lawyers, particularly in the House of Lords, who do this. There are fewer and fewer lawyers, or at least the trend is towards fewer lawyers in the House of Commons, where the political action tends to happen. So there's less correctives to, I suppose, if we can put them simplistically, anti-constitutionalist or anti-judicial independence narratives. There's also a backdrop of other cultural changes in politics that's important. I think it's true to say that constitutional conventions and norms in the UK constitution have weakened generally, not just in relation to the judiciary and to how we handle difficult court cases. We could talk about the decline of social deference, the increase in accountability cultures, which make traditional cultural approaches to judicial independence, if not untenable, then very difficult. The fact that someone is given a knighthood is no longer immunity against criticism, nor should it be. There's, as I mentioned already, there's a reduction of legal representation in Parliament, which means that there is less effective legal information, legal knowledge brought to bear on the early lawmaking stages that might impact on policy issues to do with judicial independence. So drawing this all together, I don't want to be too dramatic about what I'm saying here. I think probably the fairest thing I can say is that constitutional reform in the UK, the Constitutional Reform Act, has not demonstrably resulted in more robust judicial independence. The Constitutional Reform Act has not actually made anything any better. Now, the positive side of this is that judicial independence was already pretty robust. There isn't a terrible story to be told here. But it is true, I think, to say that in the face of the populism and the democratic decay that is a feature of Western democracies, I think, generally, as a feature of many countries, the Constitutional Reform Act has not performed a protective role. It's not a bulwark. It hasn't improved judges' status necessarily. It hasn't particularly improved their independence. And this connects to what I said at the beginning. De facto independence is much more important than legal independence. If you can get the cultural issues right, if you can get politicians to understand that they need to exercise restraint, then you've got most of the way there. The law by itself won't solve these kinds of problems. The UK is not an outlier. In common with all these other countries that we look at, again, I mentioned at the beginning David Kosar's work, formal legal protections don't mean very little without robust cultural acceptance. And, you know, to shamelessly plug my own book, for the work by Graham G and the rest of us in 2015, The Politics of Judicial Independence in the UK's Changing its Constitution, judicial independence requires political buy-in to work, requires political acceptance. It is a political achievement. And we can't, as lawyers and judges, achieve it by ourselves or through statutory means. Okay, that's me done. Thank you very much for listening.
Thank you, Dr. O'Brien. Thank you for this wonderful presentation. May I now invite our last speaker, Dr. Nauman Reayat, who recently completed his PhD on judicial independence in authoritarian and hybrid regimes from Department of Politics, University of York. His findings on online courts in Pakistan for inexpensive and speedy justice were considered by the Judicial Policy Making Committee of Pakistan during the National Judicial Conference 2018. Dr. Reayat.
Thank you very much. Thanks to all of the panelists and the attendees who registered their interest in this event. Before starting my presentation, I would like to request all of the attendees, they don't need to wait for the end of the session. They can just post their questions in the question and Q&A box at the bottom of their Zoom screens. Having this said, my today's talk is divided into three parts. The first part will explain why is it important to compare judicial independence in autocracies with that in democracies. The second part will explain how I see judicial independence and what are the different understanding in the global north and the global south. The third part will make a generic comparison of judicial independence in few autocracies and democracies. It will not be systematic because of the time constraint. And it will make an attempt to explain why the increase in judicial independence in democracies, established democracies, take longer than that in autocracies. Starting with the first part about the importance of the comparison, I will refer to Eric Stone's Street and Wellender's argument that judicialization of politics and our judicial empowerment is a global phenomenon. The idea of judicial independence flows through international organizations and are then incorporated by national organizations, state institutions. The spread of judicialization of politics or judicial empowerment across the globe also involves the citation of foreign judgments, which is very important, by the way, in the autocracies, the global south jurisdictions, learning about good and bad experiences of governance and the rule of law, and then follow good practices. However, the globalization argument tells us more about the comparison, why comparison is important for autocracies. This does not help us critically examine why the comparison is or should be important for established democracies. Building upon Wellender's and Sweet's argument, I argue that the comparison of judicial independence in two different, the global south and global north jurisdictions, is important for both states and public at large in the global north because of two main reasons. The first reason, which is related to Dr. Moohyung's argument, is that investment made by established democracies in autocracies or emerging democracies or competitive authoritarianism or hybrid regimes, there are different labels used for these legal jurisdiction in the global south. Governments in the global south spend massively on different aspects of development in developing democracies. For example, I can give you the example of the UK. The UK remained the third largest development assistance committee donor in 2019 by contributing 15.2 billion pounds. And the area of development which received maximum amount of money is the humanitarian aid, a part of which is the rule of law and the strengthening judiciary, strengthening courts, and strengthening the legal system. Besides, the rule of law is the most important component of development assistance as it affects all other aspects of development. Although it's different, the rule of law is different from the judicial independence, but an independent judiciary is one of the requirements for the rule of law. Why is it important for the public at large in the developed democracies, established democracy? This contribution, if you see, if I give you the example of the 15.2 billion contribution of the UK to the Development Assistance Committee, this contribution is a little less than 15.5 billion the UK paid to the EU in 2018 in the lieu of official payments. And we all know that one of the narratives during the Brexit campaign was the increasing burden on the UK economy because the UK contribution to the EU budget, and because of the same, people, policymakers here could not spend adequately on health, education, and other areas of social sector. And if the concern is increasing, is increasing burden on the economy, the same concern arguably can be expressed about increasing contribution to the development assistance. After all, a huge part of this contribution comes from taxpayers' money. This is where increasing judicial independence in autocracies becomes or should become the concern of public at large in established democracies. Second, judicial independence and the rule of law in autocracies is part and parcel of foreign policies of some established democracies. For example, the UK government considers the rule of law in other countries as a part of its foreign policy. According to 13th report of House of Commons Foreign Affairs Committee session between 2017 and 2019, promoting human rights, the rule of law, and strengthening the rules-based international system are essential to the foreign policy of global Britain, and that they are closely, even inextricably linked. In addition, the UK is the 8th largest donor to the Office of the High Commissioner for Human Rights, which provides the Secretary to Human Rights Council, and the 18th largest in per capita terms. However, the question is, why do established democracies spend on the rule of law project in autocracies? The reason for this huge investment is to control conflict and violence from spreading to the extent where it begins to damage economic and defense interest of established democracies in those countries. This damage could be inflow of refugees and asylum seekers to established democracies. And one of the main reasons, based on my fieldwork and the interview and the informal chats with asylum seekers and refugees, one of the main reasons behind asylum and refugees is the failure of the state institution to protect fundamental rights. Some of the autocracies are either post-conflict societies, transitional societies, where state and society have recently come out of conflict. And one of the recent example can be Afghanistan, and we have yet to see what will be the response of the UK, regarding the rule of law and the constitutional making process in Afghanistan. But having this said, the second part of my today's presentation is the different understandings of judicial independence. Now, Dr. Patrick has already covered the de jure and de facto judicial independence. But if based on my fieldwork, interviews and informal chats with lawyers, judges, civil society organizations, the first response you get when you ask the question, what is judicial independence? And that is when they say that judicial independence is when the judge makes decision in accordance with the law. And if you see the decisions made by the US Supreme Court, the UK Supreme Court, and Egyptian Constitutional Court or the Colombian Constitutional Court, all of the decisions are legal and all of them are made in accordance with the law. So then the next question, when you pose this question, the next response, the majority response is impartiality. Now that's where lawyers and the judges in the autocracies, to whom I interviewed, they look at the established democracies and say that are not incomparable because the judiciaries and the courts are not relatively less impartial in autocracies, and there it's, in the established democracy, it's more, impartial. Now, but that is a misconception. This understanding is not correct, completely correct. The understanding is incorrect to the extent that impartiality, be it impartiality, neutrality, human rights protection, or constraints on executive power, from which quantitative researchers or the qualitative researchers, they measure de facto judicial independence. It's ultimately the court's decision that indicate neutrality and that put constraints on the executive power and ensure human rights protection. And it's the compliance with those decisions, especially those decisions which are against the political interest of other branches of the state, that tell us about the de facto independence. And therefore, I will focus on the court's decision in politically salient cases, which, and in compliance with those decisions, to compare judicial independence and autocracies and democracies. Having this said, I argue that judicial independence increase in emerging democracies such as Indonesia, Colombia, Mexico, Pakistan more quickly than that in established democracies, such as the UK, the US, Australia, and Canada. For example, giving an example of the UK, it was only until human rights, in the enactment of Human Rights Act 1998, that UK courts received the power to declare incompatibility, not striking down powers, only incompatibility between the UK laws and the European Union laws. Constitutional Reform Act further contributed to the formal separation of powers by establishing the UK Supreme Court. And more recently, Judicial Review and Courts Bill 2021 equipped courts with the discretionary power to grant suspended quashing orders and prospective only remedies. However, until now, the UK Supreme Court hasn't got any power of striking down a law or striking down the executive decision in the same manner in which the US Supreme Court or the Australian High Court or the Canadian courts they do. On the other side, constitutional rights occurred in Canada through charter rights provided in the Constitution Act 1982. The US has got one of the oldest list of fundamental rights in the form of Bill of Rights. High Court in Australia, being another federal state, is equipped with strong kind of judicial review, same nature of judicial review which the US Supreme Court has got. However, in all these jurisdictions, the number of decisions against elites or political interest of the executive and parliament were a few in a year. On the other side, after the enactment of the 1991 Constitution, the Constitutional Court of Columbia made decision against the political interests of the ruling elites by recognizing gay marriages, questioning the Colombian government's inability to address the socioeconomic problems of internally displaced persons, legalizing assisted suicide, stopping President Uribe from amending the Constitution, and directing the government to bring about structural changes in the entire health system. Same can be seen in the Indonesia after constitutional reforms in 2001, where the court was equipped with the power of judicial review and made and annulled several laws enacted by the People Representative Council of Indonesia. The most surprising case of increasing judicial independence was of Pakistan, where the number of decisions against the interests of political elites in the executive, parliament, and the military massively increased after 2009, and that too without any constitutional change, which suggests that de jure judicial independence sometimes may not lead to de facto judicial independence. It may occur without, because of some different reasons. Now, why did this increase happen more quickly in established weak democracies and than that in the established democracies? One of the reasons for quick and massive increase in judicial independence in weak democracies, and which determines the timings of any increase in judicial independence in both established democracies and weak democracies, is a theory of political competition and insurance. Much has already been said about other scholars such as Tom Ginsburg in East Asian countries, Brad Epperly in Eastern European countries. I will not repeat that, but I will say the crux of the theory of political competition is that outgoing regimes voluntarily empower courts when anticipate losing power so that they can benefit from courts' empowerment against incoming regime in future. If this argument is tested in the context of the UK, one can argue that the increase in judicial independence in terms of formal separation of powers through the creation of the UK Supreme Court was a product of political competition, and because elites saw that as an insurance policy. This was visible in the timing of the Constitutional Reforms Act introduced by the New Labour. While the New Labour was planning for reforms since early 1990s and empowered courts through incorporation of Human Rights Act in 1998, it formally separated the higher judiciary from Parliament through the establishment of the UK Supreme Court in 2005. Now, the year is important right after the significant decrease in its representation in the Parliament in 2005 general elections. By the time the establishment of the UK Supreme Court took effect, the New Labour was no more in power, and it was Tories who had to face the effects of the increase in judicial independence. This phenomenon became entirely visible in two, there are other cases as well, but two cases I'll focus on. In Brexit case, regarding the Brexit, and the Miller's case regarding the prorogation of Parliament. The decision in both cases went against the government political interest and in favor of opposition. This suggests who formally separated the powers before getting out of power, received insurance after losing power. A similar explanation is offered for constitutionalization of rights in Canada by Rand Harshay. Other reasons, and I will conclude with this point, other reasons for a quick increase in judicial independence in weak democracies include direct access of public at large to the higher judiciaries, a thing which is unimaginable at this stage, at least, where, in the UK, where the government has to face, they get an opportunity to engage with public at large. And there, the importance of political elites become equal to judicial elites because both have a connection with people. And that ultimately leads to judicial populism. In conclusion, I will say that judicial independence increases in weak democracies more quickly than in established democracies because of the two main reasons. One is the political competition, the political insurance, but in addition to that, different social groups also contribute to different components of judicial independence, and also the direct access of people to the constitutional courts. These two reasons, determine these two reasons are the reasons which ensure increase in judicial independence more quickly in autocracies than in established democracies. Thank you.
Thank you, Dr. Reayat. And just I would give my perspective about the judicial independence in India in the current times. I thank all the panelists for the insights on judicial systems and working of judges in different countries and context. And I thought it would be useful to add an Indian perspective to this conversation. My views emerge from my experience as a judge and not as an academician, unlike the others on this panel today. But I imagine some of what I saw would interest many of you. Before getting into the state of the judiciary in India today, some context is useful, and I bring some bad news. We are in a situation in India right now where agencies and institutions are collapsing like ninepins. Most problematically, agencies entrusted with the maintenance of law and order are affected. The Central Bureau of Investigation or the police, for example, are routinely used and abused to intimidate political opponents and harass political activists. Coupled with this is the general polarizing atmosphere artificially fueled by the communal agenda of the ruling regime. Hate speech is now normal, with national level politicians leading the charge. The government has taken upon itself the mantle of deciding who is entitled to protections and who is not, by othering entire segment of the population, with party leaders labeling Muslims variously as beefeaters, infiltrators, traitors, and potential terrorists. To any observer, this is all clearly an expression of paranoia on the part of the ruling establishment. There is also a divisive, jingoistic idea of nationalism that is encouraged, centered on the religion and cultural identity. And worse, anyone who opposes or disagrees with government policies is branded as anti-national. Now, place in this context our judiciary, and especially the Supreme Court of India. Our Supreme Court has had a glorious part unquestionably. The statesmanship exhibited by the 13-judge constitutional bench in the decision in Keshavananda Bharati, where the basic structure doctrine was laid down and judicial custody of the constitution was reclaimed by the judiciary. The constitution was reclaimed by the judiciary, is one of the shining examples what the court is capable of. The decision essentially affirmed that the parliament can amend but cannot alter the basic structure of the constitution, which includes fundamental rights such as right to life, liberty, and any attempts of an amendment can be reviewed by the judiciary. But the Supreme Court has ups and downs, most notoriously in the ADM Jabalpur case at the height of the emergency in India in 1976, there was a realization that the court has gone astray. The following years were doggedly spent in restoring respectability. The 1980s and 1990s reversed its reputation, and for a brief period, it seemed as though the Supreme Court had returned to its being the sentinel on the qui vive, sentinel of the qui vive, which is the first generation had hoped it would remain. Now, however, we seem to have regressed once again. In my view, the start of the court's decline coincided with the coming to power of the BJP-led NDA government in 2014. This comes through most critically in judicial appointments. There was an immediate confrontation upon the NDA taking over in the form of constitutional validity of the National Judicial Appointment Commission Act 2015. The court, in a bold display of independence, struck down the legislation. All this spirit of independence, though, is sadly all gone. Today, some of the appointments and transfer of judges are decided or even orchestrated by the law ministry. There was a brief watershed moment in January 2018 where 4 Supreme Court judges, in an unprecedented move, held a press conference complaining that the then Chief Justice of India was manipulating the allocation of work to various benches. There were also occasional sparks of self-aggression, as in the right to privacy discussed in Puttaswamy, this outstanding judgment by one of the best judgments, I would say, in the democratic countries about the right to privacy, or the Shreya Singhal case, where a statutory provision in the Information Technology Act was struck down for violating the right to freedom of speech and expression, or the decriminalization of homosexuality, or recognizing transgender rights, or many cases pertaining to gender justice. But the executive is really mostly not concerned with this. You must understand this, basically. These are the issues with which a ruling regime may not be much interested. Wherever the executive is actively interested, usually in order to further its realpolitik agenda, the court gets pushed to the wall. For example, the original 2018 Supreme Court judgment in Sabrimala was extremely progressive. It permitted the entry of women into a temple previously reserved only for men. But when the state government tried to implement the court's judgment, the BJP-led center sided with the temple devotees. Review petitions filed later were kept pending for certain referred questions to be decided by a larger bench. The court said that the referral meant that the judgment was not final, and refused to issue directions on a petition by women devotees seeking safe entry into the temple. The issue of rule of law and finality also came up in the Ayodhya judgment. I mean, most of you must have heard about the Ayodhya temple case pertaining to a land. This was a land dispute between Hindus and Muslims, and basically about the destruction of a mosque. In its unanimous but unusually anonymous decision, because there is no name of the judge who wrote the judgment, the court, despite acknowledging the illegalities committed by the Hindus in 1949 and 1992, effectively rewarded the wrongdoers, including members of the party currently in power. Another manifestation of all this is the court's disinclination to take up important issues at all. In the case of colossal health crisis caused by COVID-19, the lives of migrant laborers have turned upside down, and there are millions and millions of migrant laborers all over the country. But instead of hearing the petition on this situation, for the longest time, the court refused to admit or kept on adjourning the matter at the behest of the arguments of the central government. Yet another kind of repression is the stifling the right to protest and to free speech. Spearheaded by the executive, the judiciary is either tacitly, overtly agreeing or maintaining silence over the issue. Take the protest against the clearly unconstitutional Citizenship Amendment Act, CAA, which for the first time in India uses religion as a determinant of citizenship by promising Indian citizenship for persecuted religious minorities from Afghanistan, Bangladesh, and Pakistan who are Hindus, Sikhs, Buddhists, Jains, Parsis, or Christians, but not Muslims, not to Muslims. The constitutionality of the law was challenged in the Supreme Court, but the court avoided taking up the matter for flimsy reasons. Meanwhile, the government has desperately tried to silence protesters. One academic dramatically likened the statutory and policy changes being brought about as an act of killing the constitution with 1,000 cuts. Worse still is the judgment of the Supreme Court in April 2019 in NIA versus Zahur Watali on the interpretation of Unlawful Activities Prevention Act, UAP Act, which has established high barriers of proof, making it impossible. It actually throws the burden on the accused to show that the charges are incorrect as a condition for seeking bail, and is in fact convenient to put the person behind bars indefinitely. And today, the journalists, the social activists, the academicians, many of them, hundreds of them, are languishing in jail. This is a complete negation of the rule of law, and this law is being rampantly abused by the executive to keep the protesters at bay. The Supreme Court's decline is accelerated also by a failure to perform its fundamental role as adjudicator itself. In the Kashmir case, it has practically abandoned its role as a court. Instead of itself dealing with the constitutional issues, the court handed over the exercise of advising the court in case of some internet matter, because internet was shut down for a long time, and this exercise was left to about the applicability of the judicial decisions to particular decision taken by the administration to the review committee of the administrator themselves. It's a wholesale delegation of the judicial power. Today, we have a situation where Kashmir is being ruled by bureaucrats with no political representation present. This is surely unheard of in a democracy. The Article 370, which gave some special status to the Kashmir, Jammu and Kashmir, was abrogated, and the statehood of the region was taken away. So, but the Supreme Court has refused to hear the constitutional challenges for more than 2 years. The cases are not being taken up. But finally, I would conclude with this, that I'm an eternal optimist though. Slowly, under the new Chief Justice of India, judges seem to be questioning matters again. Sedition, detention laws, Pegasus software, that's a big issue in India, where this software was used against some journalists, political opponents. And all of this, there have been public utterances by the judges who seem to be willing to question the center. Most critically, the court has demonstrated great urgency in filling up empty posts in the judiciary and is reminding the center of its duty. There's a recent orders about the appointment of judges, very large number, to fill up the vacancies in the various tribunals. So that's a big change in the stance of the Supreme Court. The point which I'm making is because today what is there in India is really, as described by some, is an elected autocracy. So it's not, I would not say it's authoritarian, but this is a very difficult phase for the judiciary in India, as it was during the regime of Prime Minister Indira Gandhi during 1970s. So the judiciary is, according to me, the judiciary is within its power and capabilities to act differently despite this political environment. And while it will be a test of character for the judiciary, it is also what will ensure that India's democratic foundations remain strong and standing. Thank you. Thank you. And with this, you may go to the question and answers.
Thank you very much, Dr. Shah. So question and answer session is now open, and we have already received three questions. Let's start with the first question. The question is by Dr. Habib Alam, barrister at law, Lincoln's Inn, UK. And the question is open to all panelists. So, do you have any advanced thoughts to keep away the judiciary from political issues, especially for developing countries? So,
I have some thought on this.
Yeah.
See, this was initially, there was a great debate whether the judicial review power could be exercised to decide political issues. But surprisingly, in India, this debate was closed long back, perhaps sometime in 60s. And with the emergence of what is known as PIL, public interest litigations, the courts are freely also going into the political and administrative matters. I'm not saying it's a good development. The original intention was to give justice to the masses, but somehow the court lost its way. But whether the courts should entertain political issues, at least the Indian courts are more liberal in taking up these issues.
Agar, would you like to answer?
If I could come in, I think that the question is interesting because I think it's something that we've seen a lot in the UK in the past decade in particular, and it's an assumption that there is a clear category distinction between political and legal. Inevitably, judges, if they're doing their job, will trespass into political issues. Anything can be political. It depends on whether it's controversial or not. So I think the short answer I have is that judges shouldn't be directly getting involved in politics. They shouldn't be pointedly, bloody-mindedly frustrating politics. They should allow it to happen. But it's impossible to ring-fence judges, judging, and the role that courts perform from politics, because these are not categories that are defined in that way. As lawyers, we tend to think of law as being this thing and politics as being this thing. But if you step back, they're completely intermingled. And a simple rule that judges should keep their hands off politics will inevitably result in the kind of politics that we've had in the UK in the last decade, whereby judges give a reasonable decision on the law that happens to have political consequences, and are then denounced from the rooftops about it.
Any thoughts from Dr. Moohyung, Roger?
I wouldn't add a great deal more other than to say I think Patrick's exactly right. Designing a hard and fast line between law and politics is basically impossible. I think the better approach would be to focus on the distinctive contributions that each of the three elements of a governmental structure can make, and instead of denouncing courts but trespassing on the role of politics, we should be focusing more clearly on trying to articulate the grounds on which the law and politics interact, and as I mentioned in my little talk, the legitimate sphere of judicial interaction with political issues.
Moohyung, you want to respond to that? Otherwise, I'm going to answer. Okay, so I will add to this thing, and I will cite one excerpt from this book written by multi-author book. One of the authors was Dr. Patrick, and the excerpt goes like this: it's the politics which increases judicial independence. What I can say, and I think you have already covered, Roger and Patrick has already covered this point, that these two things, law and politics, are inseparable in the sense that the judge's main task is to interpret the law, but the law itself is the product of the political process, and is like offspring of that political process. In that sense, it's completely impossible to keep yourself, even though judges claim. If you see the documentaries of the UK Supreme Court judges, and if you see the judgments, they religiously claim that we are not going to be involved in the politics. But the debates which they, when they start thinking about the intentions of the framers and the elites, they get into the politics, and it's almost impossible. And I will go further, that actually what we need to think about is, instead of thinking about competition among the elites, the competition among the institutions, or this claim of the review powers, that should increase, because the more, if this competition keeps on increasing, it keeps avenues for public at large open, and the choices to engage with the different state institutions and to keep check and balances on different institutions, that their choices are remained open. Now let's go to the second question, and the second question is for Dr. Patrick O'Brien. Two questions. Yeah, okay, so let's start with so the question is by Ms. Sapna Rahim, and I would like to know what he thinks about the implication of his thesis highlighting the political and legal culture as significant for maintaining judicial independence. How does this affect legal reforms and specifically academic research in this area?
Gosh, that's very broad. Okay, so let's take that in two parts. What are the implications for maintaining judicial independence? Well, I think the implications for maintaining judicial independence are that we cannot depend solely on legal constitutional structures for protecting judges or ring fencing their independence. That actually what we need, Roger, I remember at the beginning mentioned comity, and I think comity is really important. The fact that we have all these different parts of government, all these institutions, and that they need to get on with each other. One of the merits, I mean, the UK system, the historical UK system, where you've got judges in Parliament and all that, is sort of indefensible, and I don't see it returning even if it's threatened. But one of the merits of it were that all these members of these different elite groups just sort of rubbed up against each other. They met, they hung out, they were humanized in each other's eyes. And I think that some of the empirical work that's particularly done in political theory, although I think Dr. Shaw would know more about this than me perhaps, suggests that if you make judges too independent, that actually threatens their independence. And that's when I was mentioning the work by David Kosar in particular. It's a threat to them both because you can't necessarily expect judges to behave well or to respect the independence of their colleagues, but equally, if politicians and judges never see each other, never recognize each other as human, they won't see any reason to respect each other, to give each other institutional comity. How does it affect legal reform and academic research? Well, academic research can be whatever we want it to be. I think academic research needs to focus perhaps more on the empirical. Legal reform, I think I'm going to have to plead the fifth a bit there. I think this has to be very culturally determined, very contextual. It depends where you're coming from. So that will be dependent on each country and each jurisdiction and the cultures that exist there, the background cultures, I think. I might leave it at that point.
Moohyung, one question is for you, and that is regarding, the question goes like this: can we maintain judicial independence in similar ways in varied autocracies, considering the different ways authoritarians interfere with judges?
Yeah, I think this is a good question. So basically, authoritarian regimes are not the same, right? So there are several ways to classify authoritarian sub-regimes. And then here I usually follow the Barbara Geddes' classification. So the authoritarian regimes can be categorized as like the party-based dictatorship or personalist regimes and monarchy and the military dictatorship. So basically I use these four-fold classifications. So the question might be whether there might be some difference in terms of the maintenance of judicial independence depending on these authoritarian regime subtypes. So I did some similar way of like research when I write my dissertation and when I wrote my dissertation and then my current working paper. And then at the time my empirical analysis included some parts about whether the effect of foreign investment on judicial independence is contingent on the authoritarian regime types. And then at the time I found that there's some kind of regime specific effect. So Interestingly, the party-based regimes and the military dictatorship, these kind of regimes are more likely to have the higher level of judicial independence compared to the monarchy and the personalist dictatorships. And then the effect of the foreign investments on the judicial independence is quite prominent and significant in such like the military dictatorships and party-based regimes instead of the monarchy and the personalist regimes. So I'm still developing the interpretation of this finding. And then one possible interpretation might be that the party-based regimes and the military dictatorships are relatively institutionalized autocracies. So these regimes are governed by institutional organizations, but by contrast, the monarchy and personalist regimes are dictated mainly by people, persons. So in such a regime, it is more likely that the personal influence of dictators to intervene in the judicial matter, that may be more likely. So in that situation, my speculation is that the autocratic countries are not the same to deal with the issue of judicial independence. And then the autocrat's intervention in the judiciary and the resultant decline of judicial independence may be more likely in the regimes like personalist regimes and monarchies. So yeah, that's what I have. Yeah.
Thank you. Thank you very much. So let's pick question from Mark Emerton, who I believe is a member of the UK Judiciary as well. So, and the question is seems to be open. The increasing social willingness to criticize judges and judges' decisions seem to be part of general trend in society, perhaps fueled by social media. There seems to be an increasing trend, especially by litigants in person in the UK, to personally criticize the other party and the judge, and to make accusations of bias when the ruling does not go in their favor. This perhaps feeds off the political discourse, but also populist politicians may pick up on public criticism for their own aims. How far does the panel think that this is an indirect threat to judicial independence? Roger, Patrick?
Sorry, Roger, you can go first if you'd like to.
Sure. I was just going to say that, in terms of an indirect threat to judicial independence, I guess it feeds into this discourse that I highlighted earlier on. The point made by Jack Beatson in his recent book that judicial independence also extends towards the public, kind of perceptions of the judiciary and its standing within society. I mean, if it becomes routine that judicial decisions with which we disagree are denounced on the basis of the supposed bias of the judges taking them, then I think, of course, it becomes an indirect threat, becomes a direct threat to that idea of how the public perceives the judiciary. And I think it doesn't necessarily help that any number of leading politicians in recent years have kind of succumbed to that kind of criticism. We don't necessarily see engagement with judicial decisions on their merits. We don't necessarily see an appreciation that judges are constrained in many ways in the decisions that they make. Instead, we see the expectations of the politicians perhaps reflected back on judicial decisions, and politicians denounce judicial decisions in the same way that they would denounce decisions taken by opposition parties with which they disagree. They're dismissed as being, devoid of common sense. They're dismissed as being against, to take a recent example, the will of the electorate, as if these are reasonable concerns for the judges to take into account. So I think if this kind of discussion about judicial decision-making becomes normalized either via the press, by politicians, via social media, then, it does the judges a disservice. It fails to appreciate the frameworks within which they take their decisions. But equally, it becomes problematic for our kind of public perceptions of the judiciary and their role, or the judges in their role.
If I could take a slightly different slant on that from Roger, I think that you can't really distinguish this, I think, from broader social phenomena. And I think Mark Emerton earlier on mentioned a point about social deference. And I think it is partly to do with that. It's partly to do, I think, with broader issues to do with social media. So we're seeing rises in extremism, In the court system, this figures or sort of filters in with things like Fathers for Justice and the Freemen of the Land and sort of jurisdiction renunciation movements, which I think are largely organized or informed by social media. And what does this mean for the judiciary? What does it mean for society more broadly, taking this way beyond our scope here? But I think there are lots of aspects of our politics now that were suppressed in past times, pre-social media, by the fact that, I suppose to put it politely, grumpy old men in pubs just spoke to one other man in the pub and the rest of everybody left them alone. But now there is a legion of grumpy old men all over the world and they network, to take an example. And I don't know how our politics can handle this, let alone our judiciary. I think I mean, to answer the question, I don't have a clear answer to this. I think there are changes to the way that we engage with politics, with social media, the way that we think about the nature of the people as an entity and politics, specifically focusing on judicial independence. I think judges are reasonable to feel threatened. You know, I've spoken to, I suppose, particularly female judges who would have been threatened by the Fathers for Justice movement and issues to do with child custody after a separation and so on. This is a genuine threat. There were judges who felt genuinely threatened in the aftermath of the first Miller decision, the Enemies of the People headline, you know, that they were getting threats on social media. Some litigants in courts were calling judges enemies of the people and so on. Again, this is minority stuff, but it's not wrong or unreasonable for judges to feel threatened in that kind of environment. I don't have a clear answer to that. One thing that judges in the court system do and have done quite well is they've upped their social media game, they've upped their communications. There are now digestible, comprehensible summaries of major court cases that appear very, very quickly after the judgments are handed down. That helps, but that helps with the more intellectual, public-facing aspect of this. What you do about the lower level, more extremist aspect of this, I don't know. But for judges who may be listening, I have a great deal of sympathy, and the only comfort I can offer is that it's not unique to the judiciary or to the courts. It's a broader phenomenon. It's one that's faced by institutions everywhere.
I have two questions too.
Yeah, please.
I have questions to questions to both Professor Masterman and Dr. O'Brien. Basically, I feel that we should take into consideration the changing role of the judiciary. Originally the judges were deciding only the criminal and civil cases. And now with the expansion of the judicial review, the courts are entering into spheres which are normally meant for executive or legislature. I mean, this is happening all over the different courts in different democracies. So there is a demand for transparency in the judiciary. There are many times that I'm not on the allegations against the lower courts or the allegations of bias when you lose the case. I'm just overall criticism of the higher judiciary. And I believe that this is because of the changing role of the judges. Secondly, I just want to ask both of you, what about the contempt power, which is very frequently exercised by the courts in India, and not only India, but in many developing countries or colonial countries, I mean, which were under British rule. Now, for example, this enemies of the nation after the Brexit case, the Supreme Court or the High Court would have sent the editor of the newspaper to jail under the contempt law. I mean so there is a different approach, and there is a demand in India to either abolish contempt law, criminal contempt, that the criticizing the judges, that should go. But I mean, I believe that in UK, I mean, contempt law has become completely is not used for a long time. So is it possible for the UK judges, for example, who are confronted with this kind of personal allegations of bias and from the litigants and or others, whether they can use their contempt power or some inherent power to restrain the parties from
Patrick and Basil, there's a question related to this. I just want to read it out, and then you can go ahead. Thomas Garfi, asked a question, related to what Justice Shah have just posed to you. Should the UK strike a different balance between judicial accountability and judicial independence?
Okay, well, to answer the question about judicial criticism and contempt first, there was an offence of scandalising the judiciary that was abolished 8 years. I think it was Crime and Courts Act 2013 that was abolished. After it was an attempt to take a prosecution in Northern Ireland against a former minister who criticised a judge as being off his rocker in an autobiography. That was regarded as a completely inappropriate restraint on freedom of expression. So that was abolished in 2013. I don't think there is really any prospect of any kind of prosecution like that. And I think, to be honest, in the current media and public environment, certainly as it is in the UK, I think an attempt to do so would be completely counterproductive. Because in a way, it would be reinforcing the stereotype of the trope that is insisted on, so the enemies of the people, the enemies of people trope. On functional issues, the changing dimensions of judicial review, I absolutely, Chief Justice Shah, I see the point that you're making. I think that probably takes us far. I see Nauman's already saying we're running out of time. So I think that probably takes us much further than we can go in the time we have here. I think it's a much bigger issue. My view on that is that judges have always trespassed into politics because politics is this amorphous Promethean thing. And so what is acceptable, it depends on background things that are not specific to judges. Then finally, the question that you've highlighted, Nauman, on what should judges be subjected to public scrutiny in the appointment process? I don't necessarily see a problem with this if it's handled correctly. It's done in the US, but this is very controversial and everyone's scared of the US example, but it's been done in Canada intermittently in recent years to some effect. The problem is that when we were writing the book that I contributed to, published in 2015, is that no one wants to do it. Even if you think it's a good idea, there is no appetite for it whatsoever, anywhere in the government, anywhere in parliament, anywhere in the civil service, anywhere in the judiciary. Everyone looks at the US example and runs away terrified.
Roger? Want to respond?
I'm not sure I would add a great deal more than that. I mean, all I was going to say in response to the contempt point is exactly that the UK law of contempt is now very much kind of designed around reconciling freedom of expression with kind of ongoing judicial process. I mean, I guess the difficulty, I think, if I recall correctly, of the Enemies of the People episode is that it came out after the judgment had been handed down, and so there were no kind of proceedings in progress that could be damaged by that particular headline. And again, we see even in the Lord Chancellor's response to that particular headline, the balancing of issues there. I mean, I think the Lord Chancellor at that point in time, Liz Truss, said in response to the Enemies of the People headline, well, yes, we have an independent judicial process which needs to be respected, and on the other hand of the equation, of course, we have a free press which can publish as it sees fit, including heavily politicized commentary on judicial decision making. To pick up a point that's been made further down the comments by Byron, this of course highlights a problem here, doesn't it? That our traditional protections for judicial independence are about interinstitutional relationships, and they're not necessarily about threats to judicial independence which can emanate from different institutions, perhaps different branches of society or people, or and so on. So we have a kind of a reasonably limited understanding of how judicial independence can be threatened in a kind of material way by these kind of public standing of the judiciary concerns.
I think this has also answered the question put by Byron Karimba when he asked, was the Enemy of the People headline an attack on judicial independence, given that none of the traditional indicia was at risk. Source of attacks was not a branch of government. So both of you have already answered this question. So one final question, and we thanks, we thank all of attendees who put their questions, but we have run out of time, and as I already mentioned. So one final question for Justice Shah, and that is from anonymous attendee. So this is the question goes like this: if the judicial appointment through the Collegium of Supreme Court judges in India is nepotistic, unaccountable, undemocratic to the people as the election of government, then why shall the judiciary have the legitimate expectations of appointment from executive to ensure its independence? And the rest of the thing you can read out yourself. But yeah, yes, this is the question.
Just very broadly, I would answer that.
Yes.
Speaking very, bluntly, the collegium system, which is brought about by the Supreme Court judgments, certain Supreme Court judgments which were given in early 1990s, is a fraud on the Constitution. The founding fathers said that the appointment should be made by the executive in consultation with the Chief Justice and the other judges. And now it is actually turned on its head, and today the system is judges appointing judges. And the intention might be bona fide, that they felt that if judges appoint the judges, then there will not be nepotism and the other flaws, and which proved to be completely incorrect. So this is and secondly, when the government brought this Judicial Appointment Commission Act, the Supreme Court quashed the act on the ground that this affects the judicial independence. They actually mixed the issues of judicial independence with or rather equated judicial independence with the power to appoint judges. So that was a mistake, according to me. And the answer to all this is we must have a proper appointment commission, which will make appointments to the Supreme Court and the High Courts. But as it stands, there are many times there are bad appointments, very wrong transfers. There was a recent case of Justice Qureshi, one of the finest judges in the country, I would say. He's a judge from the Gujarat High Court. He has been now appointed as Chief Justice of some state in Northeast. But he has been denied elevation only because while in Gujarat High Court, he put the present Home Minister in custody. That was his order. And he passed a judicial order. And he has been denied, his elevation as Chief Justice was delayed. He was sent to a very insignificant or small High Court. So that is what is happening actually. In spite of the collegium, many times the government is calling the shots. That's a result of creating such undemocratic and unaccountable systems.
Thank you. Thanks all of the attendees. Thank you, Dr. Patrick. Thanks, Chief Justice Ajit Prakash Shah. Thanks, Dr. Moohyung Cho. Thanks, Professor Roger Masterman, for participating and for sharing your thoughts. I think we have already run out of time, and time has come to reach the to conclude the session. So the recording will be available after 1 day. So anybody who is interested in recording can send us an email, and we will send them. We will share the link with them, and they can download the recording. Thank you, everybody.
Thank you.
Thank you, Nauman. Thanks for having me.
Thank you very much.
Thank you.
Thank you.